Well, let us get back to the discipline, the core issue arising. Refer or not refer? Should it be reference and why reference? That's the query my Lord put between. I think my Lord Chief Justice put it. In fact, Justice Shah, Justice Narasimha also put it. Was Nama Brevia the basis of their case? Was it the basis of the order? Was it the basis of the entire litigation? Now, Mr. Jethwani tried to address the issue directly today morning. And perhaps he has not been rightly advised. His clients have made repeated averments directly to the contrary. Every argument of my learned friend is belied by in writing pleading. My learned friend has showed one letter to your lordships. Just note in sequence, the lordship will be astonished how much entirely relies on the Nama Brevia, which is why your lordship will refer it, unless your lordship wholesale agrees with Nama Brevia, obviously. If your lordship doesn't agree with Nama Brevia, it has to be referred. Now, remember, your lordship is considering only two issues. A, are you agreeing with Nama Brevia or not? That your lordship has already heard of the merits for us. These are the errors of Nama Brevia, they are the problems, they are the consequences. The other is, Nama Brevia is only a casual, marginal, possibly inconsequential basis of the other side's case. In which case, even if your lordship disagrees, why should your lordship refer it? Number this is completely, I'm astonished. The title is, when a resolution for removal of his own removal is pending. Mark the word pending. The next sentence should be, oh, but yesterday it was rejected. Your lordship should know that. The word pending is used, own removal is used. This is a suppression of the worst kind. Now, it's not just, I remember, I'll give you a citation. There is 1976 judgment of the lordships. Take out that. Which cites 64, just a digression for a minute. Lordship will see what standards the lordship is to maintain. And it's alright, your lordship is crowded today, so your lordship always can't maintain it. 76 Supreme Court cites 64. In 64 minutes, Mr. Setalvad appeared. I'll give those two citations to your lordships. And it was found that one of the grounds in the SLP was false or wrong, misstatement. So Mr. Setalvad appeared a second time, and the judges agreed with him and he said, I never argued this ground. It is a misstatement. I never argued the ground. And he says, we will take your statement, Mr. Setalvad, as correct. We did not grant leave on the basis of this because you never argued this ground. But we will revoke leave because there is a misstatement. Now this misstatement is the basis of getting whatever order you got on 27th.
On 27th, according to them, there was no injunction.
No, but it's kindly see, but 25th or 26th or 27th, would the speaker have disqualified or upheld and said no disqualified? Just can you go step back? This is very important. This is the biggest fiction being propounded to your lordships. Suppose there was no order by the vacation bench of this court. Just for a minute, efface the slate clean. The speaker would be at liberty on that day, which is the 27th, to either disqualify XYZ or not disqualify. The speaker had given them time to 25th, so his hands are free till 27, 2 days. Your lordship does it frequently, as I appeared for 2 hours, matter went until 9 o'clock in the night. The learned judge said that the effect is the same, we extend the time and we'll be hearing the matter. When your lordship extends the time to file a reply, can the speaker decide? Stays or interim interventions by lordships has many forms and models. They come in myriad colors. It's completely a stay. I am repeating, I was there for 3 hours and 2 days. Only Nawab was argued. Only Nawab was read. Now you can today say anything. And possibly there are video recordings of the hearing. It was argued in the evening till 9 o'clock. The learned just sat from 5 o'clock. I mean, we can disagree on Nawab, but we should not say that Nawab is on the basis of your case. This is highly troubling. This is wrong. This is not the tradition of this court. Now, your lordship has extended the stay for filing, the time of filing reply, the only effect of which is the learned speaker's hands are tied. He can't do anything. And then the judge says, the learned order says, in the interim, and then he says, I am hearing it on Monday. So, your lordship is having whatever your lordship makes of this cocktail of suppression, of misstatement, and Malas of November. Whatever Lordship will see in the overall picture. The resolution for removal of Deputy Speaker is already pending for decision, and the disqualification of the petitioner is liable to be set aside solely on this ground. Just because this is Supreme Court. Just because it suits you, you can't say today that it did not have any role, you reject it. Over. Finished. That's not your case. You moment, your Lordship knows, direct or indirect by any means, your Lordship disables the Speaker from passing an order X or Y on disqualification. That is a temporary stay. And nobody will question the Supreme Court. Nobody will go ahead after Lordship says, I extend the stay. The court says, no, there was no formal stay. Therefore, I will go and decide the disqualification. Without time. That cannot happen. The Lordship knows that. So that is my first point. On reference, it is of direct relevance. The Honourable Chief Justice put that question squarely, that please do only tell us about reference. Absent an agreement with all forms, all facets of Nagam, your Lordship would and must with great respect refer it. Distinguishing it, your Lordship has heard enough arguments, is not the correct course of action, is not going to really, it might generate more future litigation than solve any problem. Your Lordship would either, in a binary sense, agree or refer. And agreement, according to our side, is not possible for the variety of reasons given respectfully to your Lordships. Now, the second aspect is, your Lordship has been taken a lot into this 7-day, 14-day notice of intention, actual removal. That's a valid point. But it should not be thought that the reference, as and when it is decided, if made by your Lordships, is on a singular point of working out these days or the stage. The reference would raise significant issues, and one of the...
Have you formulated the issues with Dr. Singhvi?
Well, it's not in this writing form. I'll give you one page.
You can try it right now because it's now.
There are many issues, but the core issue would be. No, I'm just saying, in the light of the argument that 7 days or 14 days can be harmonized, your Lordships can hold on notice of intention to remove or the sitting. No, Manas. Your Lordship would have to decide the larger core issue.
Correct.
Which a 7-judge bench deserves to decide.
It's not just
whether your Lordships can directly or indirectly conflate Chapter 3 and 10th schedule. Or to be more precise, 179 to 182, etc. and the 10th schedule. What is the chapter? We are not saying this is the only issue. I don't misunderstand it. I am on the Nabam area point. There are many other issues. Tomorrow it will be said that I am giving up all other issues. No. On Nabam area, the issue is not about days and time and sitting. Now, why it has already been said, so I will not repeat it, but just note with bullets why this conflation is very dangerous, or at least has to be decided. The heart of the error of Nabam is a conflation, a mix-up of two distinct. One, I'm giving Rashid bullets the reason. One, not only Kyoto, but starting from Kyoto, case after case after case, constitution bench after constitution bench said, 10th schedule is a code in itself. This has been forgotten. CODE is repeated everywhere. Code in itself. Self-contained autonomous code. This word is very important, Manas. So, Manas, it's an impregnable, self-contained code. I made the point indirectly about notwithstand and subject to. But it's a code. That's Kyoto starts with Kyoto, it says it's a self-contained code. So there can't be a conflation like this. 2. There is a continuity envisaged in 10th schedule, even if a lot of adventurous action is happening in the rest of the constitution. With the Speaker. The para 6.1 Mr. Sibal read, the proviso, illustrates two things. There cannot be a hiatus, stoppage or lack of continuity in 10th schedule. Manas, they have gone that far to anticipate that he is the Speaker. This Speaker, Manas, will have a disqualification in himself because he has done some untoward act. And your Lordship has used another phrase, persona designata. Normally, Manas, in 10th schedule, the persona designata is the Speaker, and a persona designata means no one else by exclusion. That's the meaning of a persona designata. They anticipated and said, yes, it is a persona designata. But what in the strange case where I myself am facing a disqualification? No stoppage, no lack of continuity, no hiatus. Anybody else will be elected and will become the Speaker, so-called, for the 10 schedule purposes. That's proviso to 6, para 6 bracket 1 of the 10 schedule. The third reason you can't conflate, because the whole idea is continuity. The third reason is that, well, it was said, Mr. Sibal did say, but I want to elaborate on that there is no 10th schedule of the old kind, now only defences. Now, your Lordship may not have looked this time, but earlier Lordship saw. 4, 5 and 6 are very interesting clauses. The defences are very limited now. 4, 5 and 6 are the only defences. As my Lord knows, there was 3, which is conspicuous by its absence by the 91st Constitution Amendment of 1104 that deleted clause 3, the split. Now just see the nature of the defence, fellows. 1, merger. I'll not read it. That's clause 4. Now merger, fortunately for all of us, is not even alleged or pleaded or claimed by them. Forget your Lordship finding merger. It is not their case. Second exemption is, a kind of a sympathy condonation. If he rejoins, there are cases where the person will rejoin. So you have a provision by which he can be let off. That is fine. Now, that brings me to the fourth bullet under this. What is the purpose of this? Well, your Lordship will read Mr. Ashok Sen's speech when 85, this was brought in for the first time, 10 schedules. Where he said all this constitutional sin, stigma, purity, all that is there in that speech. That had happened, there were 2 actual names of actual MLAs in Haryana in 1967. These are the names of actual 2 MLAs. That's how this phrase has occurred. Now, he cites all that. Then your Lordship has these amendments to delete. The object is that defection is a per se doctrine. Defection becomes a per se doctrine because you give highest weight to maintain purity. Whereas your Lordship is, with great respect, thinking of a very, very unique, extreme case. It will be academic, it won't happen in politics. Of everybody leaving except the Chief Minister and the Speaker. Theoretically, it can happen. But well before that, everybody will leave, including the Speaker, or will be removed, as Sibal said. So it doesn't really arise. It will not, should not come into your Lordship's analysis of how to deal with this Nawab issue. The object is that as long as even the majority, or large number, or small number, minority, split, anything goes, we bring it straight, because we have found from 85 till these amendments came that the split and so many other defences were being used. So, therefore, it's a per se doctrine. In a per se doctrine is the 5th bullet. The Speaker has to get only 2 things, Kindly note that. What does he have to get? Why? He has to get, any evidence of voluntarily giving up or voting or abstaining. These are the only 2 categories. Now, second is easy. There is a whip to be shown. You absented yourself or did not vote. The first one is, your Lordship is interpreted in 10 judgments by conduct, by going to the governor, by being photographed on a podium giving speeches with the opposition. All the judgments are there. So the Speaker must act if the 10th schedule is a constitutional sin prevention. Your Lordship cannot allow the other side to ask him, you can act, but you may be biased. So that's my second point. My third point is this alacrity point. And I'm not on the general point which your Lordship asked, but on the particular point which both Chief Justice and Justice Nazima asked, on the notice period. Your Lordship said they may have some relevance to what is the notice period which the Speaker gives. Now note 2 things before I read that last judgment only. Goa, which is written has a rule of 7 days. Goa has 7 days. Both the Karnataka judgments, Yedurappa and Shriman Patil, also have 7 days. So Karnataka rule is the same as Goa. The actual notice in Ravi Nayak was 2 days. So less than the rule prescribed. This has great relevance to both the Honorable Chief Justice's query and Justice Narasimha's recollection on that, which is important. In Yedurappa, 3 days was given, and Shriman Patil, 3 days was given. Again, the rule said 7 days. The nub of the matter is that in Shriman Patil, the 3-judge bench said that what is important is not just the text of the 7-day rule in the legislative rules. Okay. The legislative rule will not be mandatory and will not be dispositive. But to consider, if anybody has to write a letter like this, when your lordship is hearing such a heavily contested matter and the speaker is dealing with it, I don't know, normally we'd expect some contempt notice. Then some appropriate case was to examine how far the arc of immunity applies. Number 4, he is actually setting up the ground as a precursor. Come to me, I will swear you in. This is an advance intimation. This 7th para read as it is can only say, come to me, I am ready to swear you in. Because you are kosher. There is no problem with you, there is no stigma. Only step left is that, nothing is left. Therefore, to the other question, my lord, the Honorable Chief Justice asked me on Thursday, what is it that you want us to do in the event that we agree with you? Or should put a question like that. One of the simplest levels, of course, I gave your lordship a larger answer, simplest level is to quash this letter. Now, suppose your lordship quashes this letter, just for a minute, and I do not press, except for 1 or 2 things, in any meaningful way for other things. Just suppose, I'm just not conceding anything, I'm just giving your lordship a supposition. The status quo ante is automatically restored.